Mahmoud involved a challenge under the Free Exercise Clause of the First Amendment. Specifically, the issue was whether the Montgomery County Board of Education's policy of introducing LGBTQ+ inclusive storybooks into the kindergarten and elementary school curriculum without allowing parents to opt their children out violated the parents' free exercise right to direct the religious upbringing of their children. The storybook series depicted pride parades, gender transitioning, preferred pronouns, playground same-sex romance, and other controversial topics. When the board first introduced the series for the 22-23 school year, schools had notified parents and allowed them to excuse their children from lessons involving these books. However, a few months later, the board rescinded this option for the following school year, 23-24. The board cited administrative difficulties caused by the hundreds of parents who had chosen to opt their children out. Parents from a variety of religious backgrounds, such as Muslim, Catholic, Ukrainian Orthodox, filed a suit challenging the storybook portion of the curriculum and sought a preliminary injunction allowing them to opt their children out of it while the lawsuit proceeded. The parents asserted that the new storybook series, combined with the board's decision to deny opt-outs, impermissibly burdened their exercise of their respective and diverse religions. Wisconsin v. Yoder, a 1972 case, the Supreme Court said there that Amish families couldn't be made to send their children to school past 8th grade, even though a Wisconsin law required schooling until the age of 16. The Supreme Court recognized the parents have a right to direct the religious upbringing of their children, and that the right can be infringed by laws that pose a very real threat of undermining the religious beliefs and practices that parents wish to instill in their children. In Mahmoud, the parents argued that if the Free Exercise Clause protects not attending high school, it must also cover their much narrower request, that is merely to skip discrete instructions that deliberately seek to confound the parents' religious values. The board argued that Yoder was a narrow holding with little application beyond its specific facts. The board argued that if families choose to attend public schools, they're not cognizably coerced by virtue of their children's exposure there to religiously objectionable ideas. If the First Amendment gives parents the right to pick and choose from the curriculum, the board said, there is no discernible limit. 6 justices concluded that the parents were entitled to a preliminary injunction, finding that the board's policy substantially interfered with the religious development of their children and imposed a burden on religious exercise similar to the burden imposed in Yoder. Applying strict scrutiny, the court found that on the preliminary injunction record before it, the board's policy did not appear narrowly tailored to serve a compelling interest, as the board allowed opt-outs in other contexts, undermining its claim that the no opt-out policy was necessary. For the 3 dissenting liberal justices, Justice Sotomayor wrote that the ruling threatened the very essence of public education because it strikes at the core premise of public schools, that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect the entire society. According to the dissent, the majority had effectively constitutionalized a parental veto power over curricular choices long left to the democratic process and local administrators, thus gutting the Supreme Court's free exercise precedent. Mahmoud made clear that Yoder is still a live, binding precedent, and unlike, for example, the Lemon v. Kurtzman test under the Establishment Clause, had not become some sort of zombie or a dead man walking case that school boards and the government can ignore.